In this part 32, we shall be dealing right from section 200 up to section 203 of the Criminal Procedure Code, and simultaneously we shall be also taking into consideration right from section 204 up to section 210 of the Criminal Procedure Code, and then right from section 211 up to section 224 is the chapter which deals with what do you mean by details as far as the charge is concerned. And once we finish with the charge, we shall be starting with the regular procedure as far as the trial is concerned, right from section 225 up to section 237 of the 37, and then rest of the sections as far as the Criminal Procedure Code is concerned. Now, this chapter, namely right from section 200 and onwards, deals with complaint to the magistrate. And before that, this is a time for me to remind you that we dealt with the chapter right from section 190 up to 199 of the Criminal Procedure Code, dealing with conditions requisite to initiate the proceedings, namely what do you mean by taking cognizance of an offence. And while dealing with this particular chapter of the Criminal Procedure Code, we have also dealt with one more part, namely right from section 467 up to section 473 of the Criminal Procedure Code, dealing with limitation for taking cognizance of an offence. Now, what are the ways in which cognizance of an offence may be taken by the court of magistrate? Barring only one exception, namely section 199 subclause 2, where cognizance of an offence is all directly taken by the court of session. Otherwise, the case is committed to the court of session for the purpose of trial by following the procedure which is laid down as far as section 209 of the Criminal Procedure Code is concerned, with which we shall be dealing as far as this part of our lecture series is concerned. With this now, if somebody goes to the magistrate and if there is a complaint to the magistrate that may be vexatious or frivolous, as a result of which, in order to overcome such a situation, what are the steps that are taken by the magistrate when somebody goes to the magistrate and complains to the magistrate is made very clear as far as section 200 of this chapter is concerned. And it reads as follows: a magistrate taking cognizance of an offence on a complaint shall, it is a mandatory provision, magistrate shall examine upon oath the complainant. So first of all, he has to examine complainant on oath and the witnesses present, if any, and the substance of such examination shall be reduced to writing and shall be signed by the complainant and the witnesses and also by the magistrate. This is the first and the foremost step that is required to be taken on the part of the magistrate before he has called an accused person to give explanation for the same. But then to this section there is a proviso, and it says, provided that when the complaint is made in writing, the magistrate need not examine the complainant and the witnesses if a public servant acting or purporting to act in the discharge of his official duties or a court has made the complaint. That is one thing. And secondly, if the magistrate makes over the case for inquiry or trial to another magistrate under section 192 of the Criminal Procedure Code, with which we have dealt in the past. Provided further that if the magistrate makes over the case to another magistrate under section 192, after examining the complainant and the witnesses, the latter magistrate need not re-examine them, is what is dealt as far as the when we start understanding the procedure that is required to be followed by the magistrate. When somebody goes to the magistrate and he wants to set a law into motion by lodging what is known as complaint, as defined by section 2D of the Criminal Procedure Code, which says complaint is an allegation which is made orally or in writing to the court of magistrates with a view that he should take action that some person, whether known or unknown, has committed an offence. Now there may be a situation that you go to the magistrate and he is not competent to take cognizance of the case. In that case, section 201 lays down, if the complaint is made to a magistrate who is not competent to take cognizance of the offence, what he shall do? He shall, if the complaint is in writing, return it for presentation to the proper court and with endorsement to that effect. And if the complaint is not in writing, direct the complainant to the proper court. That is the procedure which is required to be followed as far as section 201 is concerned. Now, the further steps that are required, magistrate has got power to postpone of issue of process, and that is made very clear as far as section 202 says, which says any magistrate on the receipt of a complaint of an offence of which he is authorized to take cognizance or which has been made over to him under section 192 may, if he thinks fit, and shall, in a case where the accused is residing at a place beyond the area in which he exercises his jurisdiction, postpone the issue of process against the accused and either inquire into the case himself or direct an investigation to be made by a police officer or by such other person as he thinks fit for the purpose of deciding whether or not there is sufficient ground for proceeding. And further part says, provided that no such direction for investigation shall be made where it appears to the magistrate that the offence complained of is triable exclusively by the court of session, or where the complaint has not been made by a court unless the complainant and the witnesses present, if any, have been examined on oath under section 200. If an inquiry under subsection 1, the magistrate may, if he thinks fit, take evidence of witnesses on oath, provided that if it appears to the magistrate that the offence complained of is triable exclusively by the court of session, he shall call upon the complainant to produce all his witnesses and examine them on oath. If an investigation under subsection 1 is made by a person not being a police officer, then he shall have a power for that in investigation all the powers conferred by this code on an officer in charge of a police station except the power to arrest without warrant. And hence now what magistrate will do before taking a decision to issue processes, he will and then calling upon an accused person, what he can do, he can inquire into the matter or he can send a case for the purpose of investigation when he thinks it fit, in order to decide whether or not there is a sufficient ground for proceeding. Now, investigation can be carried out by the police officer, or if no police officer is available, investigation can be asked to be carried out by a private person. And hence, during the past when we talked about private person coming into picture as far as the criminal procedure code is concerned, this is one section, namely section 202 of the criminal procedure code. Now, what is the result of the steps that are taken with which you are dealt right from section 200 and onwards? And that is made very clear as far as section 203 is concerned, which says, if after considering the statements on oath, if any, of the complainant and of the witnesses and the result of inquiry or investigation, if any, under section 202, the magistrate is of opinion that there is no sufficient ground for proceeding, he shall dismiss the complaint, and every such case he shall briefly record his reasons for so doing. So that is the end, or that is the proceedings will come to an end by passing an order of dismissal of a complaint where the question of proceeding further doesn't arise as far as section 203 is concerned. With this, now, if the complaint is not dismissed as per section 203 of the Criminal Procedure Code, then the next chapter, right from section 204 onwards, deals with commencement of the proceedings before a magistrate. And what he will do now? He will issue process. And if you read section 204, it says, if in the opinion of a magistrate taking cognizance of an offence, there is sufficient ground for proceeding, and the case appears to be a summons case, he shall issue his summons for the attendance of the accused, or a warrant case, he may issue a warrant, or if he thinks fit, a summons for causing the accused to be brought or appear at a certain time before such magistrate, or if he has no jurisdiction himself, some other magistrate having jurisdiction. Further part makes it very clear, no summons or warrant shall be issued against the accused under subsection 1 until a list of the prosecution witnesses has been filed. In a proceedings instituted upon a complaint made in writing, every summons or warrant issued under subsection 1 shall be accompanied by a copy of such complaint. And subclause 4 says, when by any law for the time being in force any process fees or other fees are payable, no process shall be issued until the fees are paid, and if such fees are not paid within a reasonable time, the magistrate may dismiss the complaint. Now, this also makes it very clear that nothing in this section shall be deemed to affect the provisions of section 87 with which we are dealt when we dealt with processes to compel appearance of a person in court of law. The court has got power to issue warrant in lieu of summons or in addition to summons with which you are dealt as far as section 87 of the Criminal Procedure Code is concerned. With this now, the magistrate has got power that magistrate may dispense with the personal attendance of the accused, and that is made very clear. It says, whenever a magistrate issues a summons, he may, if he sees reason to do so, dispense with the personal attendance of the accused and permit him to appear by his pleader. But the magistrate inquiring into and trying the case may, in his discretion at any stage of the proceeding, direct the personal attendance of the accused and, if necessary, enforce such attendance in the manner herein before provided. So that is as far as section 205 is concerned. With this now, what is the duty of the magistrate? And it is the duty of the magistrate to supply to the accused copy of police report and other documents, as made it very clear as far as section 207 is concerned. It says, if in any case where the proceeding has been instituted on a police report, the magistrate shall without delay furnish to the accused free of cost a copy of each of the following: 1. The police report. 2. The first information report recorded under section 154. 3. The statements recorded under subsection 3 of section 161 of all persons whom the prosecution proposes to examine as its witnesses, excluding therefrom any part in regard to which a request for such exclusion has been made by the police officer under subsection 6 of section 173. The confessions and statement, if any, recorded under section 164, any other document or relevant extract therefrom forwarded to the magistrate with the police report under subsection 5 of section 173, provided that the magistrate may, after perusing any such part of the statement as is referred to in clause 3, and considering the reasons given by the police officer for the request, direct that a copy of that part of the statement or of such portion thereof as the magistrate thinks proper shall be furnished to the accused person. Provided further that if the magistrate is satisfied that any document referred to in clause 5 is voluminous, he shall, instead of furnishing the accused with a copy thereof, direct that he shall only be allowed to inspect if either personally or through pleader in the court. So this is supply to the accused of the copy of police report and other document. As far as section 208 next is concerned, it says supply of copies of statements and documents to accused in other cases triable by court of session. And it says, where in a case instituted otherwise than on a police report, it appears to the magistrate during process under section 204 that the offence is triable exclusively by the court of session, the magistrate shall without delay furnish to the accused free of cost a copy of each of the following: the statements recorded under section 200 or section 202 of all persons examined by the magistrate, the statements and confession, if any, recorded under section 161 or section 164, any document produced before the magistrate on which the prosecution proposes to rely, provided that if the magistrate is satisfied that any such document is voluminous, he shall, instead of furnishing the accused with a copy thereof, direct that he will only be allowed to inspect if it either personally or through reader in the court. Now, this is as far as the supply of documents is concerned. Now, if the nature of this offence is such which is triable by court of session as far as last vertical column of the first schedule of the Criminal Procedure Code, namely the magistrate has got no power, then the procedure is laid down as far as section 209 is concerned, which says commitment of a case to court of session when offence is triable exclusively by it. And it says, when in a case instituted on a police report or otherwise, the accused appears or is brought before the magistrate, and it appears to the magistrate that the offence is triable exclusively by the court of session, he shall commit, after complying with the provisions of section 207 or section 208 as the case may be, the case to the court of session, and subject to the provisions of this code relating to bail, remand the accused to custody until such commitment has been made. Subject to the provisions of this code relating to bail, remand the accused to custody during and until the conclusion of the trial. Send to that court the record of the case and the documents and articles, if any, which are to be produced in evidence. Notify the public prosecutor of the commitment of the case to the court of session. So this is the procedure that the magistrate has to follow. Now there may be situation where the procedure to be followed where there is a complaint case and police investigation in respect of the same offence. Somebody has lodged a complaint with the magistrate and the investigation is also going on by the police. What to do is made very clear as far as section 210 is concerned, which says when a case instituted otherwise than on a police report, hereinafter referred to as a complaint case, it is made to appear to the magistrate during the course of inquiry or the trial held by him that an investigation by the police is in progress in relation to the offence which is the subject matter of the inquiry or the trial held by him. The magistrate shall stay the proceedings of such inquiry or the trial and call for the report on the matter from the police officer conducting the investigation. If a report is made by the investigating police officer under section 173 and on such report cognizance of any offence is taken by the magistrate against any person who is an accused in a complaint case, the magistrate shall inquire into or try to gather the complaint case and the case arising out of the police report as if both the cases were instituted on a police report. And if the police report does not relate to any accused in the complaint case, or if the magistrate does not take cognizance of any offence on the police report, he shall proceed with the inquiry or the trial which was stayed by him in accordance with the provisions of this code. With this now, if you remember, during course when we were discussing summons, there I had drawn your attention to form number 30. This is a form of the summons, though in order to understand Criminal Procedure Code, every now and then it is necessary for you to refer to second schedule of the Criminal Procedure Code and come across various forms. Now what is this section? In order to understand form number 30 as far as the summons is concerned, this has got reference. If you read under the form number 30, you come across section 206. And what is this section 206? It says special summons in case of petty offences. Magistrate has got power to issue special summons in case of petty offences, and section 106 says, if in the opinion of a magistrate taking cognizance of a petty offence, the case may be summarily disposed of under section 260 or section 261, the magistrate shall except where he is, for the reasons to be recorded in writing of a contrary opinion, issue a summons to the accused requiring him either to appear in person or by pleader before the magistrate on a specified date, or if he desires to plead guilty to the charge without appearing before the magistrate, to transmit before the specified date by post or by messenger to the magistrate the said plea in writing and the amount of fine specified in the summons, or if he desires to appear by pleader and to plead guilty to the charge through such pleader, to authorize in writing the pleader to plead guilty to the charge on his behalf and to pay the fine through such pleader, provided that the amount of the fine specified in such summons shall not exceed 1000 rupees. And for the purposes of this section, petty offence means any offence punishable only with fine not exceeding 1000 rupees, but does not include any offence so punishable under the Motor Vehicle Act or under any other law which provides for convicting the accused person in his absence on a plea of guilty. The state government may, by notification, specifically empower any magistrate to exercise the powers conferred by subsection 1 in relation to any offence which is compoundable under section 320, or any offence punishable with imprisonment for a term not exceeding 3 months, or with fine, or with both, where the magistrate is of opinion that, having regard to the facts and the circumstances of the case, the imposition of fine only would meet the ends of the justice. So this is as far as section 206 is concerned, which deals with special summons. What magistrate is expected to do? He has got power to issue special summons in case of petty offences, and there this has got reference to two sections, namely section 260 and 261, with which we shall be dealing during course of our discussion when we will deal with summary trial, when we will take into consideration trials in detail. With this now, we intend to start discussing the provisions regarding trial. But then one part, unless there is clarity regarding framing of a charge is always framed by the court of law. So we must know details regarding charge. So before we start with various trials, namely trial before a court of session, right from section 225 up to section 237, trial of a warrant case by magistrate, where we shall be dealing right from section 238 up to 250, right from section 251 up to 259 we shall be dealing with trial of a summons case, and then a summary trial with which we shall be dealing. This is the time that there is one stage, namely framing of a charge, which is a must in order to observe the principles of natural justice, namely accused person must be given a reasonable opportunity, right to hear and to be heard, and hence he must know the case which is levelled against him by the prosecution, hence the importance of the framing of the charge. Now how we can, during next part of our series of lecture, we shall be working out details regarding charge. And what I want you to do in order to understand charge, naturally what you will do, you will refer to section 2b, which defines charge, which says charge includes any head of the charge if it contains more heads than one, with which we shall be dealing. That is one thing. Simultaneously, we shall also be dealing right from section 211 up to section 224, because the heading of the chapter is charge. And then we will be clubbing the sections together for the purpose of having clarity as far as the understanding of this particular chapter is concerned. And what we will do, we will try to understand what are the contents of the charge. And in order to understand contents of the charge, we will refer to section 211, section 212 and section 213. what is the meaning of the term that is used as far as the charge is concerned is made very clear as far as section 214 is concerned, with which we shall be dealing. Now, whether court, once the charge is framed by the court of law, whether court has got power to alter the charge. And if the charge can be altered by the court of law, what is the procedure that is required to be followed by the court of law, with which we shall be dealing by dealing with two sections, namely section 216 and section 217 of the Criminal Procedure Code of this chapter. With this now, we will proceed to one more aspect as far as this chapter is concerned, and that is, generally principle is laid down as far as subclause 1 of section 218 is concerned, which says, for every distinct offence with which a person is accused, there shall be a separate charge, and every such charge shall be tried separately. Yes, but to which there are exceptions, namely which are laid down as far as section 218 proviso is concerned, section 219 enumeration as far as section 220 is concerned. We would also simultaneously deal with section 221, which deals with charge in the alternative, and then there may be cases where many persons can be charged together, with which we shall be dealing as far as section 223 is concerned. But then, can a person be convicted for an offence with which he was not charged? And for that we will refer to two sections, namely section 221 and section 222 during course of our lecture. With this, what is the power of withdrawal that is given to the court of law, that is with which we shall be dealing as far as last section, namely section 224 is concerned, withdrawal of remaining charges on conviction on one of the several charges with which we shall be dealing. And then this is a time, whatever is required to be done by the court of law is made very clear as far as the framing of the charge is concerned. But if it happens that there is some error, and hence in order to know the effect, what is the effect of error, we shall be dealing with section 215 as far as this chapter is concerned, which makes it very clear effect of errors, and simultaneously along with section 215 the time for me to remind you of section 464, namely irregular proceedings. What is the effect of it, with which we shall be dealing as we proceed further. But then, in order to again understand the part of this particular charge, time for me to remind you that this is the time where you must read form number 32 as far as the second schedule of the Criminal Procedure Code is concerned. So it becomes very easy for you to understand once you go through the draft as far as the form of the charge is concerned, during course of time as we go on understanding the same, then you will very clearly understand the importance of charge with which we shall be dealing. And then once we understand what do you mean by joinder of charges, clubbing the charges together, lumping the charges together, you will understand the definition. So you can understand definition of charge as defined by section 2b, subject to one condition, that you have understood entire chapter. We will come back, generally we start with the definition. I have also told you, but then we will come to the definition at the end, and then once you have understood joinder of charges, the definition you can understand subject to this, with which we shall be dealing as far as our next series of lecture is concerned.